It happened in a single, quiet moment, but it changed everything. With two simple words, the United States Supreme Court ended an era that Donald Trump built his entire legal survival around. Petition denied. No drama. No explanation. No delay. Just a final door slamming shut. For years, Trump's strategy had been simple: stall, appeal, exhaust the system, and hope time itself would become his shield. Every motion, every filing, every procedural trick was designed to keep the clock running until the law lost interest. But this morning, time didn't just run out, it was erased. The last path forward vanished in an instant, and with it the myth of presidential invincibility. There are no more emergency motions, no higher court, no procedural escape hatch. The road ends here. Donald Trump is no longer insulated by status, power, or delay. He is now facing immediate accountability, and inside his inner circle, shock has turned into panic. Before we break down what this ruling really means and why sources say Trump is unraveling at Mar-a-Lago, take a moment to subscribe, turn on notifications, and like this video. If you want the unfiltered truth about what's happening inside these courtrooms, including what much of the media glosses over, you're in the right place. Join our growing community so you don't miss a single update as this historic phase begins. Legal scholars are already calling this one of the most consequential rejections of a former president in American history. The Supreme Court refused to hear Trump's final appeal on his claim of absolute presidential immunity. This was his last stand. His lawyers argued that a president cannot be prosecuted for acts committed while in office. Everything rested on this theory. They believed that, even if lower courts rejected it, the Supreme Court, with its conservative majority, would at least grant a hearing. That alone would have bought them months, maybe years. Instead, the justices shut it down instantly. No oral arguments, no drawn-out process. Just a flat refusal that leaves the lower court's ruling intact. That ruling states clearly that a former president is not a king and is subject to criminal law like any other citizen. This was not routine. It was a direct rejection of the doctrine Trump used as armor for decades. What makes this moment volatile is how fast everything now moves. Normally, even after a Supreme Court denial, there's a brief procedural pause before the lower court's order becomes active. This time, the court eliminated that buffer. The ruling takes effect immediately. In legal terms, immediately means right now. The suspension that froze Trump's criminal cases is gone. Special counsel Jack Smith can proceed without delay. Judges in other cases are free to act. The dam has broken. Trump woke up believing he still had months to maneuver. He goes to sleep knowing jury selection could begin within days. Inside Mar-a-Lago, the mood is described as apocalyptic. Trump reportedly cannot process what happened. The justices he appointed, Gorsuch, Kavanaugh, Barrett, did not intervene. He believed the Supreme Court was his final shield, his ultimate escape. Realizing that it won't save him is a psychological blow deeper than any election loss. Sources describe shouting matches between Trump and his legal team, with Trump accusing them of failure. But experts agree this wasn't about lawyering. It was about law. There is no constitutional foundation for a president being immune from crimes. The court was not going to destroy its legitimacy for one man. The fallout extends beyond the courtroom. It detonates Trump's entire fundraising narrative. For months, his campaign raised millions on the promise that the Supreme Court would vindicate him. Donors were told this fight would end there. That story is now gone. How do you raise money for an appeal that no longer exists? Help me fight becomes, help me pay my legal bills before I go to prison. That shift is deadly. Donor fatigue is already visible. Major contributors are quietly stepping back. They recognize when a cause is lost. The Supreme Court strategy was the only real strategy. Without it, the campaign becomes a shell. It still moves, still speaks, still sends emails, but it is hollow. The engine that powered it has stopped. And for the first time, Donald Trump is facing something he has never truly encountered before. A system that will not bend, stall, or negotiate. The myth that he can always escape has cracked. The question now is not whether the law will reach him, but how he will react as it finally does. Now that the Supreme Court has stepped aside, the lower court's ruling becomes the law of the land, and its language is devastating. The D.C. Circuit Court of Appeals did not hedge or soften its words. It wrote that President Donald Trump has become Citizen Trump, with all the defenses available to any other criminal defendant, but with none of the special protections of the presidency. Any immunity that may have shielded him while in office no longer applies. By refusing to hear the appeal, the Supreme Court has effectively endorsed every word of that opinion. They have locked in the principle that no one stands above the law, not even a former commander-in-chief. For Trump, this is not an abstract idea for future textbooks. It is a direct path toward a courtroom and, potentially, a prison cell. Without immunity, the reality of the evidence becomes impossible to ignore. In the January 6 case and the classified documents case, Trump's defense was never built around innocence. It was built around permission. He never argued, "I didn't do this." He argued, "I was allowed to do this." That argument is now dead. The courts have ruled that no office grants the right to break criminal law. The foundation of his entire defense has collapsed. What remains is a pile of documents, recordings, witness statements, and sworn testimony that will now be presented to a jury. This moment is sending shockwaves through the Republican establishment. For months, party leaders hid behind one convenient phrase: "We have to let the appeals process run its course." It allowed them to avoid choosing sides. They didn't have to defend Trump's actions, and they didn't have to condemn him. They could simply wait. That excuse is gone. The appeals process is over. Now every Republican senator and congressman faces a simple, unavoidable question. Do you support the rule of law, or do you support a criminal defendant? There is no procedural fog left to hide in. We are already seeing lawmakers flee reporters in Capitol hallways because they don't have an answer. They fear Trump's base, but they also fear tying their futures to a man who may soon be convicted. Conservative commentator George Will captured the weight of this moment with brutal clarity. He called it the end of the road. The idea that Trump is a victim of a corrupt system has been shattered by the very institution conservatives revere most. The denials, the delays, the endless smoke, all of it has crashed into reality. The party must now decide whether it stands for law and order or for personal loyalty to one man's lawlessness. The court has done its job. Now voters and politicians must do theirs. The legal machinery that follows is ruthless in its efficiency. The case returns to Judge Tanya Chutkan in Washington, D.C. She has already made her position clear. The public has just as much right to a speedy trial as any defendant. A scheduling conference could happen within days. The trial date that was frozen during the appeal will be reinstated. Because of the timing of the Supreme Court's decision, that date now lands squarely in the heart of the general election season. Trump will be forced to spend his days in a Washington courtroom, listening to testimony about efforts to overturn an election instead of campaigning in swing states. No campaign manager can spin that image. A presidential candidate sitting at a defense table day after day is political poison. The danger for Trump goes beyond optics. With immunity gone, the evidence gathered by the special counsel becomes fully usable. There are no remaining claims of executive privilege strong enough to block it. Courts have ruled that privilege dissolves in the face of a criminal investigation. This opens the door for testimony from people Trump has always feared most, his own inner circle. Figures like Mark Meadows and Mike Pence can be compelled to speak freely. They are no longer protecting the presidency. They are protecting themselves. Silence now carries legal risk. Cooperation becomes survival. Trump's greatest fear has always been betrayal from within. He built his power on loyalty enforced by fear and reward. That system weakens the moment legal consequences become personal. When aides face the choice between Trump's wrath and prison, the calculus changes. The shield that kept them aligned is gone. What happens inside Trump's mind may become the most unpredictable element. He has lived his entire life believing that every door can be reopened, every problem negotiated, every loss reversed. He has never faced a wall that would not move. Now the wall is real. Reports describe him swinging between despair and explosive rage. He feels betrayed by the system he thought he mastered. That emotional state is dangerous. Expect increasingly extreme rhetoric, attacks on judges, prosecutors, institutions, possibly even calls for unrest. The system is preparing, security is being reinforced. Marshals are on alert. Everyone understands a cornered figure is most dangerous when he believes he has nothing left to lose. And this does not stop at America's borders. The world is watching. Allies and adversaries see a nation willing to hold even its former leader accountable. It signals resilience, but it also reveals instability. A major presidential candidate is on trial for crimes against the state. The spectacle will dominate global headlines. Diplomats are already warning their capitals that the United States is entering an unprecedented period of internal legal conflict. In the short term, it weakens America's posture abroad as domestic crisis consumes attention. For Trump, the worst-case scenario is no longer theoretical. If convicted, the charges carry potential sentences of up to 20 years. Sentencing guidelines for someone who shows no remorse and attacks the court are severe. There is no luxury confinement for crimes of this scale. Reports say the Secret Service has begun preliminary talks with the Bureau of Prisons about how to protect a former president behind bars. Think about that. Plans are being drawn for guarding a former commander-in-chief inside a federal penitentiary. That is not symbolism, that is logistics, that is reality. The media ecosystem is still struggling to absorb the speed of what just happened. For months, legal analysts speculated that the Supreme Court might take the case, slow-walk it, or push any meaningful outcome past the election. That assumption shaped coverage across every major network. Now that narrative has collapsed. Anchors are rewriting scripts in real time. The question is no longer, will Trump be tried? It is, how fast will this trial move, and what happens if he is convicted? That shift changes everything. Polling, donor behavior, campaign strategy, and even vice presidential calculations are being recalibrated. Who wants to run alongside a candidate who could be sentenced while in office? The toxicity of Trump's candidacy has multiplied overnight. At the same time, the supporters of the so-called deep state theory are already reframing this as proof of conspiracy. The system is rigged, the courts are corrupt, but that argument collapses under its own weight when the court in question is dominated by conservatives, 3 of whom were appointed by Trump himself. If Clarence Thomas and Samuel Alito are agents of a shadow government, then the phrase deep state has lost all meaning. The reality is simpler and far less dramatic. The justices read the Constitution and found no passage that grants a president permission to commit crimes. There is no clause that turns the Oval Office into a shield against prosecution. The conspiracy narrative cannot survive that basic fact. It has been intellectually exposed. As the country enters what can only be called the execution phase of this legal process, the atmosphere will grow uglier. Trump will almost certainly fire lawyers again. He will file motions designed not to win but to delay. He may attempt to boycott proceedings or provoke confrontations. But Judge Chutkan holds the authority to compel his presence. She can issue an arrest warrant. The image of federal marshals escorting a former president into a courtroom is something Americans have never seen. Yet we are moving steadily toward it. The Supreme Court has effectively washed its hands of the matter. The message is clear. The constitutional question is settled. The rest is enforcement. Silence from rival Republican figures is also telling. For months, even challengers tiptoed around Trump's legal reality. Now that the timeline is fixed, the logic changes. A candidate who can say, "I won't be in court during the election," suddenly has an argument. Party leaders are already meeting behind closed doors, fearing that they are walking into a historic defeat. If Trump is nominated while spending his days at a defense table, pressure could build for a replacement at the convention. That kind of internal rupture would be catastrophic. It would split the party in ways not seen for generations. The financial strain compounds everything. Civil judgments were costly, but criminal trials bleed money in a different way. Jury consultants, expert witnesses, security, travel, staff relocation, millions of dollars disappear every month. The Republican National Committee has signaled reluctance to cover criminal defense. Trump faces a cash crisis at the exact moment when he needs resources most. Legal pressure and financial pressure are now converging. Then there is the jury pool. The trial will be in Washington, D.C. Trump loathes the city. He received almost no support there. He knows a jury drawn from that community is unlikely to be sympathetic. That is why he fought so hard to move the case or erase it entirely. The Supreme Court's denial locks the venue in place. He will be tried in the city he tried to disenfranchise. The symbolism is painful. Trump will claim the jury is biased, but the law is clear. You are tried where the crime occurred. And the crime of attempting to overturn the government happened in Washington. The ripple effects will touch every corner of American life. This decision strengthens institutions while guaranteeing a year of chaos. The coming election becomes more than a contest over policy. It becomes a referendum on whether law applies equally. Trump will cast himself as a martyr. Biden will frame himself as a defender of order. The court has set this stage by stepping back. The result is the most volatile political environment since the 19th century. For voters who do not track every court filing, the message will be blunt. Supreme Court denies Trump's appeal. That sounds final. It cuts through noise. It punctures the aura of inevitability that strongmen rely on. Once courts treat a figure like a normal defendant, the spell begins to break. Invincibility is an illusion, and it has been shattered. The court also saved itself. Trust in the judiciary has been eroding. Had it intervened to protect Trump, it would have cemented the belief that it is purely political. By denying him, the justices reaffirmed independence. They chose the Constitution over party loyalty. Chief Justice Roberts understands that a court which places a president above the law loses its reason to exist. So this is where things stand. The final appeal is dead. Trump has no remaining legal shields. The tools that carried him for decades no longer work. The trial is coming. The evidence is coming. The witnesses are coming, and there is nothing he can do to stop it. The system he believed he could outrun has finally reached him. What happens next will test Donald Trump in ways he has never experienced. He has always believed that pressure can be redirected, that conflict can be postponed, that every crisis can be reframed as a victory if you speak loudly enough. But the law does not respond to volume. It does not negotiate with narrative. It moves forward on schedules, evidence, and procedure. That reality is now unavoidable. Every day that passes brings him closer to a courtroom where words alone no longer protect him. The emotional toll is already visible. People around him describe a man cycling between disbelief and fury, then collapsing into moments of exhaustion. This is not just legal danger, it is an existential rupture. His entire identity has been built on dominance and escape. He has never been truly cornered. Even bankruptcies ended in deals. Even scandals ended in settlements. This is different. There is no buyout clause. There is no private agreement. There is only public judgment. That kind of finality destabilizes someone who has lived on perpetual motion. This instability makes Trump volatile. Expect sharper language, more direct attacks on judges, prosecutors, and institutions. Expect an escalation in rhetoric that pushes boundaries even further. From his perspective, every restraint has failed, and desperation replaces calculation. The judicial system understands this dynamic. Security measures are being expanded. Courtrooms are being prepared for unprecedented tension. The goal is not drama, it is stability. The system knows that a figure who believes he has nothing left to lose can become unpredictable. Meanwhile, the rest of the political world adjusts. Campaign operatives are quietly rewriting strategies. Donors are reevaluating risk. Allies are deciding whether loyalty still pays. Every actor now understands that Trump's calendar will be dominated by court dates. The idea of a candidate moving from rally stage to courtroom bench is no longer hypothetical. It is scheduled. This also forces the Republican Party into a position it has avoided for nearly a decade. There is no procedural excuse left. There is no future appeal to wait for. The Supreme Court has spoken. The choice is naked. Either the party stands with the principle that no one is above the law, or it binds itself to a defendant accused of attempting to overturn democracy. That decision will define its identity for a generation. Behind closed doors, strategists are already calculating damage. They are not discussing whether Trump is right. They are discussing whether he is viable. That is a different conversation. It is colder. It is pragmatic. And it is happening now because the timeline has become real. A trial during an election is not a talking point. It is a logistical nightmare. Even Trump's most devoted allies feel the weight of this. Loyalty is easy when the leader appears untouchable. It becomes expensive when the leader becomes radioactive. Every endorsement now carries risk. Every defense becomes a headline. Every association is recorded. The protective halo that once surrounded Trump is thinning. International observers see this transformation clearly. They recognize a system forcing accountability on a figure who once embodied power. It reinforces the idea that American institutions, though strained, still function. But it also signals turbulence. A nation putting a former president on trial during an election is not projecting calm, it is projecting conflict. Markets, allies, and adversaries adjust accordingly. For Trump, none of that matters compared to the personal reality. His daily routine is about to change. Instead of dominating cable news, he will sit silently while others describe his actions under oath. Instead of commanding a room, he will listen. Instead of dictating terms, he will respond to questions he cannot control. That reversal is profound. The myth that he is untouchable has been central to his power. Once that myth fractures, everything else becomes negotiable. Support weakens, fear evaporates, opponents become bolder. The Supreme Court did not just deny an appeal, it stripped away a story Trump has told for decades, that rules apply to others, not him. This is why the moment feels heavier than any election. It is about whether power in America is conditional or absolute. It is about whether a man who reached the highest office can be treated as a citizen again. The court has answered that question. Now the country must live with the consequences. This is the moment where theory becomes reality. The question is no longer whether the American system can hold a former president accountable. That experiment has already begun. What remains is to see whether the pressure fractures institutions or strengthens them. The Supreme Court has stepped back, not in weakness, but in resolve. By refusing to intervene, it has affirmed a principle older than any political party. The law does not recognize rank. There are no exceptions written in invisible ink for those who once held power. For Donald Trump, the path forward is brutally narrow. There is no higher authority to appeal to. There is no procedural fog to hide inside. The shield he carried for half a century is gone. What remains is exposure. The trial will come. The witnesses will speak. The evidence will be displayed in open court. And every moment will be recorded for history. The coming weeks will be loud. Trump will fight in the only arena he has left. Rhetoric. He will frame himself as a martyr. He will claim persecution. He will attempt to turn every procedural step into proof of conspiracy. But beneath the noise, the machinery of justice will continue. It does not argue. It does not posture. It moves. For voters, this is unfamiliar territory. The United States has never tried a former president in this way. Many will feel unease, even discomfort. But discomfort is not disorder. It is the price of accountability. Democracies are not defined by how they protect the powerful. They are defined by how they restrain them. This decision also marks a quiet restoration of the court's credibility. Trust in the judiciary has eroded in recent years. Had the justices shielded Trump, the institution might have been permanently damaged. By refusing, they chose endurance over allegiance. Chief Justice Roberts understands that a court that elevates one man above the law ceases to be a court. It becomes a tool. This ruling preserves the boundary between power and principle. Trump now stands where he has never stood before, alone before the law. No title, no immunity, no special treatment, just a defendant. That transformation is more significant than any pole shift. It is the collapse of a personal mythology. History will not remember this as a single order. It will remember it as the moment when delay stopped working, when the strategy of endless motion failed, when a man who believed time itself could be bent discovered that some systems do not yield. The trial will not be quiet. It will dominate headlines, it will inflame passions, it will test patience, but beneath every argument and every broadcast, one truth will remain steady. The law applies to everyone. The era of waiting is over. The era of accountability has begun. Stay with us. Subscribe to this channel. We will follow every development, every witness, every motion, every turn. The headlines will tell you what happened. We will tell you what it means. Do not look away. History is unfolding in real time.